Good morning to all the third BCom computers and general students. Subject we are going to learn today is about principles of insurance, and this class is revision class. I am going to explain you the unit 2 question and answers, important question and answers which are going to appear for the final examination. So the question what is going to be there here is, question is what is insurance and what are its types of insurance here. Question. So see the answer. First, the meaning of insurance. Insurance, it is represented in the form of a policy, an agreement, a contract between two people, that is contract insurer and insured. The contract agreement between these two people is going to start with the policy. So who is insurer is, insurer refers to an insurance company or other organization that offer insurance. So who is insurer? Insurer is a insurance company or other organizations that offer insurance. Insurance is also called as carrier. Okay. Insured. Who is insured? Insured may be a person or an organization covered or protected under an insurance policy. So insured may be a person or an organization covered or protected under the insurance policy. So what is coverage? Coverage refers to extent of protection under an insurance contract. So coverage refers to the extent of protection under insurance contract. Claim refers to the demand of money what we paid for the policy. The amount what you are going to demand comes under policy. So insurance here is represented in the form of policy. Insurance is a contract in which the individual or an entity gets the financial protection. In other words, reimbursement from the insurance company for the damage, big or small, caused to their property. So the insurance is represented in the form of the policy. Represented is shown in the form of policy. I repeat once again. So it is a contract between two people, that is insured and insurer. So the agreement between these two people is going to start with the policy. It's going to start with the policy. Policy may be a bond or the documentation which is going to start after we pay the first claim amount or first premium. What is premium? The regular payment, the periodic payment which is going to be paid by the insured to the insurer for covering the risk in future comes under premium. So premium plays a very important role for starting this agreement between these two people, that is insured and the insurer. So the organization which is controlling this payment of the premiums, agreement between these two people, policy holder, claimant, etc. comes in the organization which is called as a insurance. The insurer and insured enter a legal contract for the insurance called the insurance policy that provides financial security from the future uncertainties. In simple words, insurance is a contract, a legal agreement between two parties. The individual named insured and the insurance company called insurer. In this agreement, the insurer promises to help with the losses of the insured on the happening contingency. The insured, on the other hand, pays a premium in return for the promise made by the insurer. In simple words, insurance is a contract, a legal agreement between two parties, that is the individual named insured and the insurance company called as insurer. It is agreement the insurer promises to help with the losses of the insured on the happening contingency. The insured, on the other hand, pays a premium in return for the promise made by the insurer. So, the principles of insurance. In principles of insurance, concept of insurance is risk distribution among a group of people. Hence, cooperation becomes the basic principle of insurance. To ensure the proper functioning of an insurance contract, the insurer and the insured have to know of insurance between an insurer and insured is based on certain principles. Let's know the 7 principles of insurance mentioned below. There are 7 principles of insurance which are mentioned below. The first and the foremost point is utmost good faith, proximate cause, insurable interest, indemnity, subrogation, contribution, loss minimization. I repeat the points once again. Utmost good faith, proximate cause, insurable interest, indemnity, subrogation, contribution, loss minimization. These are the 7 principles of insurance. The fundamental principle, first and the foremost principle is principle of utmost good faith. The fundamental principle is that both the parties in an insurance contract should act in good faith towards each other. That is, they must provide clear and concise information related to the terms and conditions of the contract. The fundamental principle is that both the parties in an insurance contract should act in good faith. Who are the two parties? The two parties are insurer and insured. Both the two parties should be submitting their information clearly with transparency. The insured should provide all the information related to the subject matter, and the insurer must give precise details regarding the contract. Clear details and all the details should be given by the insured to the insurance company. Example, Jacob took a health insurance policy. At the time of taking insurance, he was a smoker and failed to disclose this fact. Later he got cancer. In such a situation, the insurance company will not be liable to pay the financial burden as Jacob concealed important facts. He did not reveal that he is a smoker, that is a chain smoker of cigarette. Because he did not mention, the insurance company is not taking the responsibility of paying any claims regarding his health issues. So, this type of transparency should be maintained. Both the parties, the insured and the insured, should be clearly giving the information before they start the policy or come into agreement of the policy. Principles of proximate cause. This is also called the principle of cause proxima or the nearest cause. This principle applies when the loss is result of 2 or more causes. The insurance company will find the nearest cause of loss to the property. If the proximate cause is the one in which the property is insured, then the company must pay compensation. If it is not a cause the property is insured against, then no payment will be made by the insured. I repeat, this is also called the principles of cause proxima or the nearest cause. This principle applies when the loss is the result of 2 or more causes. The insurance company will find the nearest cause of loss to the property. If the proximate cause is the one in which the property is insured, then the company must pay compensation. If it is not a cause the property is insured against, then no payment will be made by the insured. Example, due to a fire, a wall of the building was damaged and the municipal authority ordered it to be demolished. While demolition, the adjoining building was damaged. The owner of the adjoining building claimed the loss under this fire policy. The court held that fire is the nearest cause of loss to the adjoining building and the claim is payable as the falling of the wall is an inevitable result of the fire. Okay, it is clearly understood. I think both the sides, the clear information is the nearest cause for which the insurance company is not ready to pay the claim. Clear? In the same example, the wall of the building damaged due to fire fell down due to storm before it could be repaired and damaged an adjoining building. The owner of the adjoining building claimed the loss under the fire policy. In this case, the fire was remote cause and the storm was the proximate cause. Hence, the claim is not payable under the fire policy. One more example he gave, and clearly he explained in this that because of the storm, the wall has been fallen down, they repaired, and because of the fire accident, if any damage to that wall, the company is not going to pay any claim under the fire insurance policy. Principle of insurable interest. This principle says that the individual insured must have an insurable interest in the subject matter. Insurable interest means the subject matter for which the individual enters the insurance contract must provide some financial gain to the insured and also lead to a financial loss if there is any damage, destruction or loss. I repeat the point here. Who should be careful here? Insured must have insurable interest in the subject matter. Means subject matter for which the individual enters the insurance contract must provide some financial gain. He is having some interest to pay the policies because in return he is going to expect or he is going to gain more than what he paid. If there is no damage, destruction or loss, financial loss may not be there even though he is going to get the expectation there is a gain. Example, the owner of a vegetable cart has an insurable interest in the cart because he is earning money from it. However, if he sells the cart, he will no longer have an insurable interest in it. Okay, to claim the amount of insurance, the insured must be the owner of the subject matter both at the time of entering the contract and at the time of the accident. Okay, so both the places the insured must be present. In case the insured is not present or he died, then the secondary alternative methods are going to be chosen for paying the claims. Next one is principle of indemnity. The principle says that the insurance is done only for the coverage of the loss. Hence, insured should not make any profit from the insurance contract. In other words, the insured should be compensated the amount equal to the actual loss and not the amount exceeding the loss. The purpose of the indemnity principle is to set back the insured at the time financial position he was before the loss occurred. Principle of indemnity is observed strictly for the property insurance and not applicable for the life insurance. This is not for life insurance, it is for which insurance? Property insurance. Also, if you see the example, you can understand the above information what is given. The owner of the commercial building enters an insurance contract to recover the loss for any loss or damage in future. If the building sustains structural damages from fire, then the insurer will indemnify the owner for cost to repair the building by way of reimbursing the owner for the exact amount spent on the repair or reconstruction the damaged areas using its own authorized contractors. Example is clearly given to you that if the building owner insured the property and he caused any damage and the damage has been reconstructed or repaired, that amount is going to be paid by the insurance company. Next, principle of subrogation. Subrogation means one party stands in for another. One more person is entering in the field of insurance on behalf of you. As per this principle, after the insured, that is the individual has been compensated for incurred loss to him on the subject matter that was insured, the rights of the ownership of that property goes to the insurer, that is the company. Subrogation gives the right to the insurance company to claim the amount of loss from the third party responsible for the same. Subrogation gives the right to the insurance company to claim the amount of loss from the third party responsible for same. If Mr. A gets injured in a road accident due to reckless driving of the third party, the company which Mr. A took the accidental insurance will compensate the loss occurred to Mr. A and will sue the third party to recover the money paid as claim. This example is clearly explaining to you that the third party who committed the accident is liable to pay the insurance or liable to pay the compensation for this party A for whom the accident has been caused and damage has been caused. So insurance company, Mr. A may be having the insurance policy, but what is happening? This insurance company is taking the amount from whom? the person who committed the accident. From there it is taking the amount and claiming this Mr. A. Principle of contribution. Principle of contribution applies when the insured takes more than one insurance policies for the same subject matter. It states that the same thing as in the principle of indemnity. That is, the insured cannot make a profit by claiming the loss of one subject matter from the different policies or companies. So, one policy, one rule, and he can't make the profits by cheating and submitting the fraud reports, etc. Example, you see, a property worth rupees 5 lakhs is insured with company A. A property worth rupees 5 lakhs is insured with company A for 3 lakhs and with company B for 1 lakh, and the owner in case of damage to the property for 3 lakhs can claim the full amount from company A, but then he cannot claim any amount from company B. Now, company A can claim the proportional amount reimbursed value from company B. The owner in case of damage to the property for 3 lakhs can claim the amount from whom? From A, but then cannot claim any amount from company B. Now, company A can claim the proportional amount reimbursed value from the company B, contribution. So, how much he paid, he is expecting that can be get in return. Principle of loss minimization. This principle says that an owner, it is obligatory on the part of the insurer to take necessary steps to minimize the loss to the insured property. The principle does not allow the owner to be irresponsible or negligent just because the subject matter is insured. So he is telling that don't be careless because you have the insurance. If a fire breaks out in your factory, you should take responsible steps to put out the fire. You cannot just stand back and allow the fire to burn down the factory because you know that the insurance company will compensate for it. So you clearly understood from this example, I think. Your factory is burning and you are standing and still waiting to completely burn the company means, yeah, of course insurance company is going to pay, but you are going to be at loss because the company may not pay the total amount. Clear? So it want to reduce the amount and it want to make you to realize that you should take care about your property. Clear? Thank you, students. It is one of the important answer for the final examination. This is the revision class only. This is not the explanation class, means I mean the normal class. So many students may get the doubt that madam is going little bit fast. Of course, these all topics I explained to you. I am repeating second time or third time for you. Third time I am doing the revision, means in revision class this is a topic repeated third time. So that is the reason I am little bit fast. It is one of the important long answer for the final examination. I request all the students to note down if possible and start revising because exams are going to be appear very fast. Thank you, students. Thank you very much.